Hello, thank you for joining us today. My name is Michael Barber. I'm with attorney Michael D. Barber and Associates. And today we're going to discuss some legal terms that might help you have a better understanding of what you're facing if you have a criminal charge. One of the basic foundations and precepts that we have in law is something referred to under the Fourth Amendment, and that is your right against unreasonable search and seizure. One of these precepts is used on a day-to-day basis, and that is called reasonable articulable suspicion. And we normally refer to that as RAS. And typically what that is when an officer examines a situation and he believes that there is going to be some criminal activity or criminal activity is afoot. So that is a fancy way to say that we think a crime is about to happen. Now, the Fourth Amendment, as I said earlier, is what drives this precept, and that's the Fourth Amendment to the United States Constitution. Well, that's all great, Mike. So, reasonable articulable suspicion, fantastic. Not sure how that's going to help me understand what I'm looking for if I have to defend against the case. Well, let's put it in context for you. We had a client that we represented. This was originally in Duluth Municipal Court, and she was stopped for DUI. And this is just one of many examples of how this can work. That DUI involved an officer who was sitting stationary, and in the report, I believe he said he was blacked out, running a laser. And our client was coming down a accessory street, and she turned right and went into a school parking lot at about 11 o'clock at night. So the officer, to quote, said, "I found this very suspicious because I drove through the middle school before and there was no reason for anybody to be there at 11 o'clock, so I followed her in, activated my lights, and stopped her as it appeared the driver was looking for an exit to get back on the road." So, he argued that we had reasonable articulable suspicion because she shouldn't have been in that particular area. Why was this important? Well, this was our client's second in 5 DUI. And as this will be the first of what we hope will be many video blogs, we are hoping to explain why this is important at a later date, but to give you an idea, on a second and 5 DUI conviction, there is a minimum amount of jail time that you are expected to serve, as well as a 18-month license suspension with no opportunity to have a temporary license to drive on. So this was pretty important for our client. My argument in this, we had to have a motions hearing, and this, as I said, this started in Duluth Municipal Court. And when we finished, we were in Gwinnett State Court. My argument was that there was no reasonable articulable suspicion, that she was merely turning around, and that there was no criminal activity in any of that. Ultimately, we had to have a motions hearing on it in front of a judge, and the state's argument was that they put their officer on the stand, and he talked about reasonable articulable suspicion, of course. The reason that this motion was so important, though, is because our client actually did the fields and took the test, and she blew a .18. So that was an elephant that was in the room that we probably weren't going to be able to get rid of unless this worked. However, after everything was said and done, we had our motions hearing in front of the judge, and I explained to the judge that she was just turning around and that there was no reason for the officer to stop her vehicle. And in the end, the judge took his time, went and researched some case law, which he didn't have to because I had already given him the case law. But he agreed. There was no reasonable articulable suspicion for someone turning around in a parking lot. Now, that doesn't mean that that's going to work every time, but in this particular situation with the facts that were involved in this case, the judge agreed with us. And he said there was no articulable suspicion for the stop. And he suppressed all the evidence after the stop, which means that all of the fields were gone and the breath test was gone. This inevitably led to a null pros of the case by the judge, and that's one example of how reasonable articulable suspicion can actually assist you in getting your case dismissed. Now, that doesn't mean that it's going to work every time, but that's how important the Fourth Amendment is for us, because the Fourth Amendment is your right against unreasonable search and seizure. And that particular case is a perfect example of how unreasonable search and seizure works, because the officer had no reason to stop the vehicle, therefore all the evidence was suppressed. We hope that you enjoyed this little foray into just one legal term, and we plan to do this a little more to try and assist everybody in understanding how the law can apply to you and how it works, and we hope you'll join us next time. I'm attorney Michael Barber with Michael D. Barber and Associates.